If you're living with somebody in Colorado, you might be married in the eyes of Colorado law, common law married. That might sound okay until one of you is ready to move on. That's when things can get complicated. It's important to know how common law marriage works in Colorado. I'll explain what you should know about common law from both sides of the relationship. One of the first questions I'm always asked by clients in this situation is, what is a common law marriage? A common law marriage is established by the mutual consent or agreement of a couple to enter into the legal and social institution of a marriage, followed by conduct that shows that mutual agreement to be married. The core question is whether the parties intended to enter into a marital relationship. That is, whether they intended to share a life together as spouses in a committed, intimate relationship of mutual support and obligation. A common misconception about common law marriage is that you have to be in it for a specific period of time. That's not true. It is important, however, because the longer you're married under common law, chances are the more evidence you will have created to show that marriage. Plus, the longer you act like you're a married couple, the more likely it is that a court will find that to be a marriage. That's especially true when a party denying the marriage has repeatedly agreed that he or she was in the marriage and never objected. Proving a common law marriage can be very difficult. The issue only really comes up after a relationship ends, and unfortunately, that's when parties tend not to remember what they said to each other. But there are often pieces of evidence that can help to establish the intention of the parties. This could be a ceremony that you might have had in the past. It might be an anniversary card that you give to your spouse where you refer to them as a husband or a wife, or any other card for that matter. A joint loan application, joint bank accounts, taxes that you might have filed together. Examples of events where you were introduced as a spouse, especially if there are witnesses available. This is the type of evidence that can establish the intention of the parties to be married. The more of it you have, the more likely you are to prove a marriage. It's important to note that the same evidence that might establish a common law marriage can also be used to defend against a common law marriage in court. If a couple, for example, files separate tax returns or has separate bank accounts, that tends to show a lack of marriage. If they don't have a party on their insurance, or they give the other party birthday cards or anniversary cards that refer to them as boyfriend or girlfriend rather than a spouse. Other evidence of how parties introduce each other to friends and family also matters. Very often they have friends or family come to court and say, "I never was aware they were married," is very good evidence to defend against this. Finally, there may be some legal barriers to a common law marriage. For example, the parties may agree to sign an agreement which says they're not married, or one of the spouses is still married to somebody. We are here to help you whether you're trying to establish a common law marriage or defend against one. There are two sides to every story, and not surprisingly, there are often valid points on both sides. Because these issues often come down to private statements and circumstantial evidence, persuading a court can be difficult. That is where a seasoned lawyer comes into play. We are here to advocate on behalf of you. Reach out now for a case assessment.